Namaste and welcome to an overview of Employees Provident Fund and Miscellaneous Provisions Act 1952. Provident Fund is a resource planned for future. It is a product of prudence and foresight. Therefore, it is a very important legislation from the point of view of an employee. The Employees Provident Fund and Miscellaneous Provisions Act 1952 can be understood through its objectives and scope, its three schemes which are of great importance as they have been developed over a period of time, and also the administrative mechanism for achieving the objectives of the Act. An overview of the various components of this Act is quite significant. As the Act is a welfare legislation, it aims at ready financial assistance to employees and their families in times of need. Let us enter the Act proper. Under the object and scope, we have social security or monetary assistance as one of the major objectives of the legislation. Then the term which is frequently used in all schemes of the Act is monthly pay. Monthly pay has got four components: basic wages, dearness allowance, retaining allowance, and cash value of food. But in the normal course, only two of these components are predominating and they are in actual practice. That is basic wages and dearness allowance. This particular concept is more important just because all contributions under various schemes of the Act are linked to the monthly pay, and we will get into the details of this through court judgments a little later. We have three more concepts: factory or establishment, employer and employee, which we will see in a bit of greater details. Factory or establishment. The Provident Fund Act applies to every factory specified in Schedule 1 where 20 or more persons are employed. It also covers a factory which is notified by central government. The 20 persons which is indicated is at the entry level. If the number of persons goes down below 20 after it has attracted the Act, it doesn't make any difference. The logic is once covered, continues to be covered, even when the number has fallen below 20. The definition of the factory, as including premises and precincts thereof wherein a manufacturing process is being carried on, and what is the meaning of a manufacturing process, remain the same as defined in the Factories Act. We have to note that the Employee Provident Fund Act doesn't apply to a cooperative society, and it also doesn't apply to an establishment of central government or state government which has got a scheme similar to that of Epf Act. And there is a third set of establishments which are called as permitted establishments, who have their own systems and which have been approved by the central government as being permissible. And the fourth establishments are those which have been exempt by a notification of the central government. This is the factory which attracts the EPF Act coverage. Then comes the employee. If you look into the definition of employee for the sake of Provident Fund Act, anyone who is employed in the normal course of business or in connection with the factory or establishment is an employee. He can be a sweeper, he can be a watchman, he can be a gardener, or he can be a subcontracted employee hired through a contractor, or he can be, say, a BD worker who works at home but for a BD employer or BD manufacturer. What is important here is the certainty of employment. That means to say, employee under EPF Act doesn't cover casual employees or uncertain employees or a contingent employees, and it also doesn't cover apprentices. And there is one more set of people who are not covered by the Act. If an employee draws a salary exceeding rupees 15,000 per month, he is outside the scope of this Act. Then the question arises, what if a person when he joins is less than 15,000 salary and after some time it crosses 15,000? Is he within the scope or outside? It's quite simple. Salary when he enters is important, and subsequent changes in the salary are not material. Once he is an employee of the factory and becomes member of Provident Fund Act, he continues to be a member even if the salary goes beyond 15,000. And the Act focuses on employer-employee relationship. And an employee attracts the Act from the very day of his joining. There is no time lag between joining and becoming a member. You join and you automatically become a member of the EPF, Employee Provident Fund. Then employer. We have got the standard definition under the Factories Act, who is a owner or occupier. Owner owns the factory, or there may be an agent of such owner or legal representative of a deceased owner. When it comes to occupier, he is the one who has the ultimate control over the affairs of the establishment. An occupier may be known by different designations like a manager, managing director, executive manager, managing agent. What is more important in respect of an occupier is the control over the affairs of the factory. Generally, occupier includes employer and officers of such employer. Thus, we have seen the objective of EPF Act. What is factory or establishment? What is the monthly pay salary? Who is an employee and who is an employer? That makes us go to the next topic as to what are the schemes available under the Act. The Employees Provident Fund and Miscellaneous Provisions Act of 1952 has got along with it three schemes. The first scheme out of it is Employees Provident Fund Scheme 1952. This is the initial scheme that came with the Act. It aims at a provident fund for employees to which there is a compulsory contribution, which gets monetary support to him after his retirement or demise. After the Provident Fund, there came the second scheme of Employee Pension Scheme in 1971. Once again, to provide pension to a retiring person or to his family in the event of his demise, and which was followed by Employees Deposit Linked Insurance Scheme of 1976, which provided for life insurance cover to an employee with the beneficial payment going to the nominee of the employee after his death. Now, these are the three schemes which are included in the Employee Provident Fund and Miscellaneous Provisions Act 1952, and we will get into each of these schemes and understand their key features in the process. Let us first take up the Employee Provident Fund Scheme 1952. We will be looking into three aspects of it. What is the scheme and its contribution? What happens to the fund that comes into the scheme? How is it invested? And what is the return that we get? And how can the money be withdrawn from the system? The scheme expects the employer to contribute 12% of monthly pay to the EPF account of the employee. Of this amount, 3.67% will go towards EPF and 8.33% will be towards employee pension scheme. Employee is also required to make a matching or higher contribution. It is the responsibility of the employer to deposit the contribution of both before 15th of the ensuing month. Of course, employer is entitled to recover the employee's contribution from his regular payments. The Board of Trustees of EPFO are responsible to invest the Employee Provident Fund accumulations as per plan approved by central government. The accounts of the employees will be credited with the interest at the end of every year at rates as approved by central government. For instance, for 2018-19 the rate was at 8.65%, while for 2019-20 it is set at 8.5%. The amount standing to the credit of an employee in EPF account is withdrawable. There are two methods, namely partial withdrawal and complete withdrawal. Partial withdrawal is permitted subject to 1. Minimum service requirements and 2. Financial limits. The purposes covered are marriage, medical treatment, education, home loan repayment and home renovation. It's worth noting that if the employee is over 54 years of age and his retirement is due within 1 year from now, he is allowed to withdraw up to 90% of his accumulations. The scheme also provides for complete withdrawal. Complete withdrawal is allowed after 58 years of age and retirement. Both conditions are to be fulfilled. Complete withdrawal is also allowed in case of death, permanent disability or unemployment for a continuous period of 2 months. Complete withdrawal is also possible when an employee gets transferred to a factory which is not covered under the Act. Thus we have seen Employees Provident Fund Scheme 1952, what is the scheme, how investment is done, how interest is credited and how could it be withdrawn by the employee under various heads. Next scheme which is there is Employee Pension Scheme, which talks of payment of monthly pension to the employee or his family. We will be looking at it from its scheme and contribution and also the monthly pension per se. Along with this, there is a court decision as regards employee pension, which is quite interesting for getting a better grasp of the Employee Pension Scheme 1995. Let's get into the Employee Pension Scheme contribution. Now this scheme, the moment an employee joins the organization and is enrolled with the Employee Provident Fund, he becomes a member of Employee Pension Scheme. As we have seen, out of employer's contribution, 8.33% goes into pension scheme, and we have to observe that government also adds its share of 1.16% as matching contribution every month. In EPF we have seen there is an annual interest added, but here there is no concept of annual interest. There is a formula for calculation of pension from the age of 58 until death. It is a small pension, but it is a guaranteed pension. Only requirement here is the employee should put in minimum 10 years of service before he retires. However, if the employee retires but he has not put in 10 years of service, he will not be getting pension, but he will be within his rights to withdraw the full amount of accumulated EPS contributions. Monthly pension is paid on completion of 58 years of age and retirement for the rest of life. It's also given where there is permanent total disablement, and in the event of death of the employee, it will be paid to the widow for life or to minor children till they reach 25 years of age, and it is also available for dependent parents for their life. The monthly pension is calculated simply by a formula as pensionable salary into pensionable service divided by 70. Pensionable salary is the average salary, basic plus DA, over last 60 months of service. Interesting to note, this pensionable salary was considered as average of 12 months only up to September 2014, when there was an amendment made to the scheme by the government. And that amendment also fixed that the monthly salary, average whatever comes, it cannot exceed 15,000 per month. It put a cap on that. Therefore, average for 12 months was there, it became average for 60 months, and it also kept a cap of 15,000. For example, if the average for 60 months is coming to 17,000 rupees, but for the sake of pensionable salary, there is a cap of 15,000, we will be using 15,000 in place of pensionable salary. Pensionable service is the number of years service put by the employee. Once again, if the number of service is more than 35 years, it will be restricted to 35 years. And the normal rule is that of 6 months and above, rounded off as 1 year, less than 6 months is ignored. And we have an illustration which says it is the formula is quite straightforward and simple. This particular change of September 2014 has given rise to a litigation. That litigation is represented in the case Epf organization versus Sunil Kumar and others. Just to get the background of the case, Employees Pension Amendment Scheme 2014, it was a decree passed which said new employees who are enrolled with the EPF, we saw that if at the time of entering, if it is below 15,000, he is allowed entry into the system. But if he crosses 15,000 after joining, he will continue as a member. But this particular amendment said, if he crosses over rupees 15,000 per month of monthly pay, he would not be eligible for employee pension scheme benefits. Means he will not be getting the employee pension. Number two, before this amendment, the monthly cap for the sake of pensionable salary was 6,500. This particular amendment raised it to 15,000, which was to the benefit of the employees. Number three, before the amendment, pensionable salary was the average for only 12 months. But here, the amendment suggested it should be averaged over last 60 months, because average over a longer period is always lesser than average over a shorter period. And that is to the disadvantage of the employee, because it is a multiplier. Employees who were aggrieved with this amendment, they moved Kerala High Court, and Kerala High Court struck down these changes, and subsequently Provident Fund authorities moved Supreme Court, and Supreme Court upheld the decision of Kerala High Court. Now, with the Supreme Court judgment, the three changes which were brought in: number one, 15,000 per month if it is crossed, no monthly pension. Monthly cap of 15,000, average over 60 months instead of average over 12 months. These three changes are struck down, and we have to go back to what was there before the amendment. But till date, there is no clarificatory circular from EPFO, and the confusion continues. But one thing is sure, that compliance with this is required. But it has got a lot of issues involved. What happens to people who joined after September 2014, who were not eligible for EPS benefits, but because of this latest decision of Supreme Court, they will be eligible? Number two, if 15,000 monthly cap is maintained, then for this EPS, employers have to contribute, and that amount has to go for pension scheme rather than from EPF. And monthly pension was based on 12 months average earlier, but with the amendment it was reduced to 60 months. Now when it is restored, it will be an issue. Now, so much for Employee Pension Scheme 1995. We have the third scheme of Employee Deposit Linked Insurance Scheme, and we will be looking at it from two aspects: scheme and contribution, and assurance benefit. What is the scheme? Scheme is, you are an EPF member, you are eligible for an insurance policy. Employer will contribute up to 0.5% of the monthly maximum salary as the premium, and there is no requirement for minimum service. EPF account nomination works here also, and whoever is nominated under EPF account becomes a nominee under the insurance policy. Employee is covered for the life insurance, and the life risk is covered. And assurance benefit goes to the nominee. Here the beauty of the thing is, this particular welfare legislation ensures that every employee on the sad demise will be eligible for payment to his nominee a minimum of 2,50,000, which can go up to rupees 6 lakhs. The amount of benefit which goes has got two components. One, 30 times his average monthly wage for the last 12 months. You take the average of last 12 months and multiply it by 30 times. Second, whatever EPF balance he carried during the 12 months, 50% of it will be added as an insurance compensation. Both put together, it should result in a minimum of 2,50,000 rupees, and it can go up to 6 lakh rupees. 6 lakh rupee is the ceiling. This is a wonderful benefit to the employees. Besides this, we have got certain aspects to be just understood in terms of authorized officers named under the Act: Provident Fund Commissioner, Additional Provident Fund Commissioner, Deputy Provident Fund Commissioner, and others, who will be looking into the amount due from employer, and they have got the right to conduct inquiry, visit, inspect, and pass decisions. Any decision of the authorized officer can be appealed against with the tribunal as regards dues from employers and determination of escaped amount. The Act also provides for appointment of recovery officers for recovery of dues under the Epf Act. And the Act very specifically states, under no circumstance the employer will reduce any of the benefits such as pension, gratuity, provident fund or life insurance in terms of his employment just to provide for coverage under this Act. And whatever payments due to the employees under the Provident Fund Acts and their various schemes, employees will have the first claim on the assets of their employers, and they will have preference in terms of getting the money in the course of liquidation, and no court can pass an attachment order on dues to any member of the Provident Fund under its various schemes. We have a latest decision of Supreme Court in respect of monthly pay. We understand that monthly pay, which is the basis for contribution of employer and employee, comprises four things: basic salary, dearness allowance, retention allowance, and cash value of food concession. Besides this, companies are paying various other allowances as a part of their remuneration planning. And that way, the monthly pay which attracts PF contribution was suspected to be reduced to have a lower financial implication. There was this case of Vivekananda Vidya Mandir and others, wherein the regional Provident Fund authorities approached the court stating there has been intentional reduction in the monthly pay by paying it as special allowances. The Supreme Court agreed with the suggestion of regional Provident Fund authorities, and it held that special allowances which are paid at fixed rates such as education, conveyance, telephone, etc. should be a part of wages. They are not variable. And the principle that Supreme Court depended upon was the test of universality. If an allowance is paid to everybody as a fixed amount, it is universal. If it is universal, it is a special allowance. If it is a special allowance, it has to be a part of monthly pay. Meaning, on that, there has to be payment of contribution of employer and employee. There is no circular from EPFO on implementing the decision of Supreme Court, which came in February 2019. However, the government has already proposed the Epf Bill 2019, which, when passed, will amend the PF Act and incorporate these things. The implication will be there will be more financial outgo for the employer towards the various provident fund schemes. As we have seen, the complaint return